What if I told you that 3 simple words could make a real difference in protecting your Social Security benefits? Not complicated legal language, not expensive lawyers, just 3 ideas most people don't realize have real weight when benefits get reviewed, reduced, or even denied. And right now, a lot of seniors feel uneasy. Social Security letters are showing up in mailboxes. Reviews feel more frequent. The rules can seem like they're always shifting. For many people, it starts to feel like the system they counted on for years has become harder to understand and harder to trust. But here's what often gets missed in the middle of that stress. Even when things feel confusing, there are still protections built into the system. And knowing even a small part of those protections can completely change how you respond if your benefits are ever questioned. Today, I want to break this down in plain language, what recent court attention around Social Security protections really means, and the 3 words that can help you stay calm, informed, and prepared if something ever lands in your mailbox. Because when it comes to your income, your stability, and your peace of mind, knowledge isn't just power, it's protection. When people hear Supreme Court or Social Security ruling, it can feel distant, like something meant for lawyers and policy experts. But court decisions often influence how benefits are handled in the real world, how rules get interpreted, how reviews are done, how evidence is weighed, and what procedures the agency has to follow. Not always dramatically, not always overnight, but gradually through policies and processes that affect retirees, disability recipients, and survivors. Now, one important clarification before we go further. There is no magic phrase that guarantees benefits or overrides the law. That's not how Social Security works. But there are legal standards and procedural protections that matter a great deal, and people who understand them tend to handle notices and reviews far more effectively than people who assume every letter is final. So when I say 3 words that could save your benefits, I'm really talking about 3 legal ideas that come up again and again in benefit decisions and court interpretations. And those ideas are due process, substantial evidence, and the right to appeal. Let's start with due process. Due process basically means the government cannot just change or stop your benefits without following required steps. In everyday terms, it means you are entitled to notice, an explanation of why something is happening, and a chance to respond. This matters because people often receive letters that are confusing or full of formal wording. And when you're already worried about rent, medication, or groceries, it's easy to read that letter and think that's it, there's nothing I can do. But due process exists to prevent rushed or one-sided decisions. A lot of people lose ground not because they aren't eligible, but because they don't respond in time, or they simply don't realize they're allowed to respond at all. Now let's talk about substantial evidence. This one sounds technical, but it's actually very important and very practical. Substantial evidence means that any decision about your benefits must be supported by enough reliable information, not guesses, not assumptions, and not incomplete records. If Social Security is reviewing your case, whether it's disability status, income, or eligibility, their decision is supposed to be based on documentation and facts that actually hold up. And here's the key takeaway. Even if a letter looks official, it doesn't automatically mean it's correct. If the evidence is weak, missing, outdated, or wrong, then the decision can often be questioned and challenged. But most people never do that because the letter feels final and permanent, which brings us to the 3rd and often most important protection. Every person receiving Social Security benefits has the right to appeal a decision they believe is incorrect or unfair. This is not a favor. It is not optional. It is a legal right built into the system. If benefits are reduced, stopped, delayed, or denied, you can request a reconsideration. If that doesn't resolve the issue, you can request a hearing. And if necessary, the process can continue to higher levels of review. Yes, it can feel slow or stressful, but here's the most important point. A notice is not the same thing as a final, unchangeable outcome. Many people successfully restore or correct their benefits through appeals, especially when the issue comes down to documentation, miscommunication, or missing records. Now let's bring all 3 of these ideas into something even more practical. Imagine you open a letter saying your Social Security benefits are being reduced. Panic is a natural first reaction. These benefits often cover the basics of everyday life. But instead of reacting emotionally, the strongest move you can make is to pause and think in terms of your protections. Ask yourself, did I receive proper notice and a clear explanation? What information are they using to justify this decision? And do I have the option to appeal? Just asking those questions shifts you from feeling powerless to feeling prepared. And that shift matters more than most people realize. Because many benefit problems are not actually about whether someone qualifies. They are about outdated information, a missing form, a wrong assumption, or an error in records. Large systems handle millions of cases. Mistakes can and do happen. And these protections exist because the system is designed to allow correction when something goes wrong. There is also something emotional here that deserves to be said honestly. For many seniors, Social Security is not just income. It is independence. It is dignity. It is the stability that comes from a lifetime of work. So when anything threatens that, even temporarily, it feels deeply personal and overwhelming. That is exactly why understanding your rights is so important. Not to create fear, but to reduce it. Because uncertainty is often worse than the problem itself. And clarity changes everything about how you respond. When you know you can question a decision, you are less likely to accept something that may be incorrect. When you know evidence must support a change, you are more likely to ask for clarification. And when you know an appeal process exists, you are less likely to feel trapped by a single letter or notice. So if there is one takeaway from everything discussed today, it is this. You are not meant to navigate this blindly. Due process means you must be treated fairly and informed properly. Substantial evidence means decisions must be backed by real support, not assumptions. And the right to appeal means you always have options if something doesn't look right. These are not just legal terms sitting in a textbook somewhere. They are active protections designed to keep the system from becoming completely one-sided. And they only work when people actually know they exist. Protecting your benefits is not about fear. It is about awareness. And awareness gives you choices. So stay informed, stay aware, and take care of yourself because what you have earned deserves to be protected.